Before this hearing even gets underway, you can already tell this judge isn't interested in excuses, technicalities, or second chances that haven't been earned. The defendant is facing an assault of a family member charge, and according to the allegations, the alleged victim isn't a stranger, a neighbor, or someone she barely knows, it's her own mother. That's what makes this case immediately stand out. Family violence cases are often some of the most difficult situations courts handle because emotions, history, and personal relationships are deeply intertwined. But here's where things get even more serious. The judge isn't just looking at a single allegation. He's looking at a reported history of violence, concerns about substance use, and the possibility that prior interventions may not have solved the underlying problem. That's why you're about to hear repeated warnings about alcohol, drug testing, bond conditions, and protective orders. Every one of those conditions is designed to answer a single question: can this defendant safely remain out of custody while the case moves through the legal system? Pay close attention to how the judge reacts when he learns more about the allegations and the defendant's background. You'll notice that his focus isn't simply punishment, it's prevention. He's making it crystal clear that if he believes there's any ongoing threat to public safety or to the alleged victim, he's prepared to act immediately. And then comes the twist nobody expects. As the hearing unfolds, the alleged victim herself appears in court, and what she has to say creates a situation that judges see all too often in family violence cases. The court now has to balance what the victim wants with what the law requires. So here's the question for you. If a family member says they've worked things out after an alleged assault, should the court back off, or should the judge continue imposing strict protections anyway? Let us know what you think as we watch this drama.
And I'm going to tell you now, I'm going to do everything in my power to protect every single person of this county. And if that means putting you in jail, I'm going to do it in a heartbeat. Do you understand? I'm sending you now for a drug test. I want to know what, if anything, is in your system, then you're to come right back. If you fail to come back, or if you fail to take the drug test, I will revoke your bond. And I'm going to tell you now, you will not get any more PR bonds. Do you understand?
Yes, sir.
As a condition of your bond, I'm forbidding you from having any contact with Diana Morelli whatsoever, not to consume any alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. I'm also ordering you not to be in possession of weapons as well. I'm ordering you not to have contact with her. Can you find Mom, please?
What we're witnessing here is a judge sending a very deliberate message. Notice that he isn't merely finding probable cause and moving on to the next case. Instead, he's emphasizing public safety over convenience, and that's significant. According to the allegations, the complainant reported being physically assaulted, suffering visible injuries, and there's even mention of a prior assault involving the same family member. Whether those allegations are ultimately proven in court is a separate issue, but at this stage, the judge is evaluating risk. That's why the drug test becomes such a major factor. The court isn't necessarily claiming that drugs or alcohol caused the alleged incident, but judges often view substance abuse as a potential contributor to future violations or dangerous behavior. The repeated warnings about bond revocation tell you exactly how seriously this court takes compliance. And here's something worth thinking about. If you were the judge and saw allegations involving repeat family violence, would you release the defendant with strict conditions, or would you consider holding them in custody until the case is resolved? The answer isn't always simple, and that's exactly why hearings like this can become so intense.
Called a magistrate's order for emergency protection that identifies you as a protected individual. Ms. Morelli, you cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? This is a second assault alleged against you. The first one was dismissed. However, now I'm forbidding her from having contact with you. I've also forbidden her from consuming alcohol or illegal drugs, and I'm sending her now for a drug test because I want to know what, if anything, is in her system. I'm so much as even contemplating putting a device on her ankle so I know that she's not consuming any alcohol. She has a lot of prior violent behavior, you know, and I'm going to do everything in my power to quell it. This is the fifth, violent type of case that we have, and that's it. Historically speaking, every 2 years, there's a new case. Since 2018. Stops now. Do you understand?
This is one of the most revealing moments of the entire hearing. The alleged victim has now appeared, and according to court staff, there are indications that she believes the situation has been resolved between her and her daughter. In many family violence cases, that's not unusual. Victims and defendants often have ongoing relationships, shared homes, financial ties, or emotional bonds that make these situations incredibly complicated. But notice what the judge does. He doesn't immediately relax the restrictions simply because the parties may want reconciliation. Instead, he doubles down on protective measures. From the court's perspective, the question isn't whether everyone feels better today. It's whether there's a risk of future harm tomorrow. The judge even references multiple prior incidents and makes it clear that he views this case as part of a larger pattern rather than an isolated dispute. That's why he's discussing protective orders, alcohol monitoring, drug testing, and the possibility of additional supervision. This raises an interesting question. Should a judge prioritize a victim's wishes when they want contact restored, or should the court focus primarily on preventing future violence, even if the parties disagree? Cases like this show just how difficult that balance can be.
The last condition, Judge, if I could, it asks Ms. Morelli to contact pretrial to determine the case status. She has counsel, Judge. So can we remove that? Right?
I've never seen that, actually. You'll have to show me that, what hurts. Usually it's something where it's random testing. Why?
I have no idea.
Okay, I'm gonna take that off. I don't see why. Thank you for bringing it. I've never seen that before.
I never seen it either.
It was through the magistrate, so we'll take it off. Ms. Morelli, I'm going to have you sign conditions now. You are not to have any threatening or harassing contact with your mother. What is threatening or harassing doesn't matter what you think is threatening. It's what she perceives. So if you buck up and go like this, is that threatening or harassing? It is. Spoken word, it doesn't have to be spoken word. Other conduct can violate this court order. If you violate this, I'm going to put you in jail. You will not get any more PR bonds. If I find that you're consuming alcohol, and I don't care what it is, I don't care what the source is, isopropyl alcohol, rubbing alcohol, a tequila lollipop, hair dye, NyQuil, I've heard it all, and it doesn't matter to me. No means no. And we'll take copious notes that I've warned you about everything, including mouthwash, Listerine, whatever it may be. If you test positive, the bond gets revoked, you go to jail. And from now on, if you test positive, I'm telling you now, I'm going to put an ankle monitor on you that tests for alcohol. And that thing costs around $400 to $500 a month. You understand?
Yes, Your Honor.
So everything in this order for protection will stay. The only thing that we're taking off is the residential restriction. So before you leave here, I would suggest that you get to know this thing so you know what you can and can't do. Do you have any questions?
I can contact her and be around her, just nothing harassing or threatening.
No threatening, harassing, no alcohol from any source, no illegal drugs. Correct. You have a lawyer. They will take care of you. It's your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You will not get any more PR bonds if you pick up a new case, you start acting out, anything like that. Any questions?
Just Monday and Thursday.
You will report here at 9 o'clock in the morning. We'll send you the test. And then after that, you'll be go. And then you can go. If we find something we shouldn't, we'll get in contact with both of you guys. Okay? If you don't show up, a warrant will issue.
Is there a time frame that it matters for those days?
9 o'clock here in the morning. Yeah. Okay.
Yes.
We
All right,
excuse,
guys.
Judge. Thank you.
Thank you.
As this hearing comes to a close, the judge's overall strategy becomes crystal clear. Rather than focusing solely on punishment, he's creating a framework of accountability. The defendant remains subject to strict bond conditions, mandatory reporting requirements, alcohol restrictions, drug testing, and a protective order designed to prevent further conflict while the criminal case proceeds. One of the most notable aspects of this hearing is that the court maintained its protective stance even after learning that the alleged victim appeared willing to communicate and potentially reconcile. The judge repeatedly emphasized that his responsibility is to protect individuals and the broader community, particularly when allegations involve recurring violence. Whether you agree with every condition imposed or not, the message from the bench was unmistakable. Compliance is not optional. Violating the court's orders could result in bond revocation, additional restrictions, or jail. Cases like this remind us that family violence allegations often involve difficult decisions where safety concerns, personal relationships, and legal rights all collide in the same courtroom. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Thank you.